Well, hello everybody and welcome to this UCL Centre for Ethics and Law webinar discussing the recommendations of the UK Independent Expert Panel on Corporate Re-domiciliation. I'm Anna Donovan, I'm the Director of the Centre for Ethics and Law and an Associate Professor of Corporate Law here at UCL. Our speakers today need no introduction, and nor does time permit me to do justice to their respective bios, which are available in full on the event registration page. However, by way of brief introduction, I'm delighted to be joined by Vanessa Knapp OBE and Chair of the Expert Panel on Corporate Re-domiciliation, and UK representative on the Company Law Committee of the Council of Bars and Law Societies of Europe. Vanessa is a Senior Research Fellow at Harris Manchester College, Oxford, a Visiting Professor at Queen Mary, and an Honorary Professor at Brunel Law School. Dr. Edmund Schuster is an Associate Professor of Corporate Law at the LSE and a member of the Management Board of the European Company and Financial Law Review, as well as recipient of the Modern Law Review Wedderburn Prize for his article on the law and economics of the mandatory bid rule. Alongside his academic work, Edmund holds an of-counsel position with Baker McKenzie. In terms of format today, Vanessa will start the discussion by introducing the report for about 20 minutes or so, following which Edmund will offer his thoughts and discuss the pertinent aspects of the report with Vanessa. Time permitting, there will be a question session after the main discussion, so do please submit your questions throughout the webinar using the Q&A function on the screen. I will then moderate the questions, and time permitting, we will ask as many of those to the speakers as we can. Please note that today's event will be recorded and the recording will be available on the Centre website shortly. So against that, I'm delighted to hand over to Vanessa for this afternoon's discussion. Vanessa.
Thanks very much, Anna. And I'm just looking for my slides, which of course have magically disappeared from where they were before. There we go. So hopefully everyone can see those. Thanks very much to the Centre for inviting me to talk about this report. I'm very keen that as many people as possible should take an interest in the report and contribute their ideas as to how we can make it better. The background to this is that the government did consult on corporate redomiciliation back in 2021 and published the report of the feedback that they got on that. And then they asked the Independent Expert Panel to come up with some specific proposals as to how the law might be changed. I'll start off with redomiciliation into the UK. Our idea was to try and make this process available to as many bodies corporate as possible. So it doesn't matter what jurisdiction you're in, as long as you're registered in the jurisdiction where you are. But we did think it should be limited to solvent bodies. So if you're insolvent or you've had a receiver or administrator appointed, or you're in liquidation or you're undergoing some sort of scheme of arrangement or compromise, you wouldn't be able to move to the UK then. I think probably the same is true for if you're subject to resolution tools or powers or mechanisms under the EU directive, but not being a regulator, I felt it was probably better to get the regulatory specialist to express a view on that. We did suggest that the Secretary of State have a reserve power to stop companies coming from particular countries if for some reason it was thought that there was a problem with that country. That might be used occasionally, not too often, we hope. The way we think this should work is that a company wanting to come to the UK would apply to Companies House, and that the sort of information they would be providing would be as close as possible to the information you would provide if you were incorporating a UK company in the UK from scratch. We thought about whether you should have to be a similar sort of body corporate to a private or a public company. And given that we have procedures under the UK law for companies to change their form, we thought probably you didn't need to do that because you would be providing the same information as someone setting up from scratch. But we also thought that because you exist already, you ought to be providing some additional information So, for example, relating to your share capital, do you have treasury shares? Are there outstanding share options? Are there buyback agreements in place? That sort of information people should have access to. Information as to whether you've got share premiums in place. Also information about whether you've got existing debentures and charges. And if you have prepared accounts under your existing regime, a copy of the latest accounts that have been disclosed. We thought it was important that companies coming to the UK should be solvent. And so what we're proposing is that something similar to the solvency statement used on a reduction of capital should be used, and that statement should be made by the people who are going to be the directors when the company becomes a UK company. So they would both be saying that the company, the directors have no ground for thinking that it won't be able to pay its debts, and that will continue to be the case for the next 12 months. And they will have to take account of contingent and prospective liabilities in the same way as they would if you were doing a solvency statement on a reduction of capital. And then just in case the process for coming to the UK lasted longer than expected, more than 6 months, we also suggested that the director should be required to renew the solvency statement in that sort of a case. It's going to be up to the applicant to decide how they transform whatever their share capital has been under their existing regime into what is going to be share capital for UK purposes, and how their existing capital and reserves are going to be treated. Given the enormous range of possibilities, we really didn't think it was going to work to try and deal with that as a matter of UK law. We think that it's really for the law of the existing jurisdiction to provide protections for shareholders and creditors in that jurisdiction, and that the only requirement that the UK should be imposing is to ask the body corporate to confirm that they are meeting the requirements of their jurisdiction to leave that jurisdiction and become a UK company. And so that would be one of the confirmations that the body corporate would give to Companies House as part of their application. In the consultation, the government has suggested that there might need to be a good faith requirement. The panel, having thought about that, really couldn't see how that was going to work in practice, what would count as good faith and what would not count as good faith. And Companies House really hasn't been set up to make those sorts of judgments. It's not a regulator like that. So our proposal was that there shouldn't be a good faith requirement. And also from a national security point of view, our view was that if you're coming to the UK, you're more likely to be subject to UK regulation, and therefore we didn't think there was a national security element that you needed to worry about on an inward redomiciliation. This is going to be relatively technically complicated, I think, and so we thought that it should be the applicant who should be in charge of dealing with all the various regulators, the regulator in the country they're leaving and Companies House. And they may have other regulators too, if they're a financial services business, for example. And they'll be very focused on making sure that the date when they become a UK company and have to start meeting UK requirements is something within their control. So we suggest that they should be able to propose the date on which they want it to take effect, subject to a minimum period to give Companies House enough time to deal with the application, and that it should be possible to change that date as they go along, because they probably won't be able to control the timetable of the regulator in the country they're leaving. So that bit might need a bit more thinking, I think, once government has made a bit more progress on how all this is going to work. And then the idea is that once Companies House is satisfied that you've provided all the information you need to, they would tell you that in principle your application is approved. And again, this is to do with making sure that it actually takes effect on the date and at the time you want it to, and that would only happen when a certificate of re-domiciliation is issued to you. There could be a period which we think should be relatively short, in which you could be registered in 2 jurisdictions at the same time. You obviously don't want to cease to be registered in your existing jurisdiction before you've become registered in the UK, But conversely, once you're registered in the UK, you'll probably need to go back to your existing jurisdiction and confirm that that has happened. What we're proposing is that there'll be an obligation on you to provide evidence to Companies House that you have been deregistered in your previous jurisdiction, and that if you didn't do that within whatever the set period was, which might be 30 days, 60 days maybe, that Companies House would have the power to strike you off, so that you couldn't stay as a dual registered company indefinitely. The panel thinks that it's important that the law sets out exactly what the effect of redomiciling to the UK is, and that's certainly the approach taken in other jurisdictions. So you become a UK company when your certificate of redomiciliation is issued, and the law would set out that you are the same legal person with the same rights and liabilities that you had beforehand. Particularly for public and listed companies, there could be some practical difficulties in having UK law applied to you straight away. And so we thought that those companies certainly should have the possibility of being able to pass some resolutions in advance, conditional on redomiciliation taking place, and that the law should make it clear that that will work. So particularly things like authority to directors to allot shares, or authority to directors to buy back shares. Disapplication of preemption rights would be another one. And it would be good if the law made clear that those resolutions would count and work for UK purposes. Once the company's redomiciled, we think it'll need to issue new share certificates. That's part of the applicant being in charge of what their share capital is going to look like. And they're also going to have to start meeting all the normal UK requirements. So a register of directors and secretaries, a register of members, register of people with significant control. They'll have to be set up to have that in place from the moment that redomiciliation takes effect. There will need to be some additional requirements for companies that have redomiciled, and we thought it would be a good idea if you could tell by looking at a company number that they were a redomiciled company, because they will be a slightly different kettle of fish from a company that was incorporated in the UK from scratch. So we just suggested putting an R in front of whatever their registered number is going to be. We think that the company should be able to choose what its accounting reference date is going to be, and I'll say a bit more about that in a second. Distributions was another area where we could see that there might be some difficulties, partly because in the UK we have this rule of only being able to make distributions out of the excess of realised profits over realised losses. And companies may be coming from a jurisdiction where those concepts don't exist at all. They might have a more solvency-based approach to dividends. So we thought that the Act needs to do something to help those companies. And what we're suggesting there is that directors should have to make a reasonable attempt to work out whether their profits and losses are realised or unrealised. But that if they can't do that after making reasonable inquiries, that the law should say that they would be entitled to treat their profits as being realised and their losses as being unrealised. And the reason we suggested that is that that's what happened in 1980 when the concept of realised profits and losses was first introduced. And so we thought a similar sort of approach would be good, but instead of using a 1980 date, using the date at which the company redomiciles. Insolvency is another area where you might need some additional provisions in order to deal with the fact that the company has existed before it moved to the UK, particularly in cases where there's a look-back period. The starting point will be that UK insolvency law will apply to you after you've become a UK company in the normal sort of way. But you can see that, for example, in cases where there's a look-back period of 2 years, that 2 years could go back before your redomiciliation date. And so the law, I think, would need to make it clear that the court's entitled to look back to what happened in that period. That then raises some interesting questions about, well, what if the action that you took was lawful under the law of the country where you were incorporated? And our general view on that was that if something worked and was okay under the previous law, that's how it should stay, and that you should continue to give effect to something that had worked under the law that applied to it at the time. But again, that needs to be spelt out in a bit more detail for these redomicile companies. Another whole area is everything in the Companies Act and how that's going to apply to a company that has re-domiciled. And so there's a whole chapter in our report with detailed recommendations as to how the various sections should apply to that. And I'll say a bit more about that in a second. And then the other area is tax. And again, the starting point is that once you become a UK company, the presumption would be that you would be UK tax resident, unless there is some particular reason for that not to be the case. And there shouldn't be a separate tax regime for re-domiciled companies. As far as possible, we want to treat these companies in the same way as a UK company would be treated. But we recognise that there's likely to need to be more guidance and possibly some tax legislation, particularly on the transition in, or for redomiciliations out, on the transition out of the UK. I'm not a tax lawyer, so I'm not going to say much more about that. On accounts, we thought companies should be able to have a choice as far as possible for their accounting reference date. So if they've got a date they want to keep, they should be able to do that. But they should also be able to change it. But as you'll know, for UK companies, there are limits as to the changes you could make. And we thought there should similarly be limits as to what redomiciling companies could do. And like a UK incorporated company, the default ought to be that your accounting reference date will be the last date of the month on the anniversary of your redomiciliation. Then we looked at accounting reference periods. If you have had a balance sheet date, then we think your next accounting reference period should end more than 6, but no more than 18 months after that last date. And again, if you haven't had a balance sheet date, there should be a default of preparing accounts for a reference period between 6 and 18 months after the redomiciliation takes effect. There was a bit where the panel wasn't sure it was sufficiently competent to make a definitive suggestion. So we've suggested some options in cases where the company wasn't required by its previous law to prepare accounts, or was required by its law to prepare accounts, but hadn't yet got round to doing so before the redomiciliation took effect. And we're hoping that people who deal with these sorts of things every day will help come forward with some views as to how best to make this work. And then the other area is what financial reporting framework should apply to you. At the moment, we have laws in the UK that say if you are a company who've got securities registered in the US or traded on a Japanese stock exchange, you have a 4-year transitional period for using US or Japanese GAAP. And what the panel suggests is that that should apply to other sorts of generally accepted accounting principles, which are treated as being equivalent to IFRS. So that might be Canada or Korea, for example. And again, that's all part of trying to make the UK an attractive place to come. As I say, there's a whole chapter devoted to detailed changes to the Companies Act. And again, if anyone has the time and inclination to look at those, we would certainly welcome any thoughts on that. There are certain expressions which we think could be dealt with more generally. So where the Companies Act says you must do something at all times, making it clear that for re-domiciled companies, that means at all times from re-domiciliation, not pre-re-domiciliation as well. And references to certificate of incorporation that should include certificates of incorporation on re-domiciliation. And I've already mentioned this idea of having special rules for resolutions that were passed in anticipation of re-domiciliation. We think it would probably be a good idea that these detailed changes should go into a schedule so that for anyone who's interested in re-domiciliation, they can find all the changes in one place. But for people just dealing with a company incorporated in the UK from the beginning, they wouldn't have to worry about those. The sorts of things that might need some special rules, for example, directors' duties, where there are, for example, under 175, where you've got the duty to avoid a conflict of interest unless it's been authorised, you might need to have a grace period so that the company can get the authorisations put in place after they've re-domiciled, and so directors aren't in breach of their duties at that stage. Turning now to moving out of the UK. Again, any company in the UK that's solvent should, we think, be eligible to move out of the UK. So not if you're being wound up or you're involved in a scheme of arrangement that hasn't yet been implemented. And again, the same sort of question about what if you're subject to resolution tools. And again, what we suggest is that it should be Companies House that deal with an application. And in this case, the company should be confirming that the laws of the jurisdiction it wants to move to do allow it to re-domicile there. Again, it would be the company that would be in charge of sorting out when the re-domiciliation is going to, or when it wants the re-domiciliation to take effect. We thought it was important for people dealing with a company that wants to re-domicile that they would know about that. So we suggested that you should have to tell Companies House when you send out your notice of meeting to shareholders or written resolution asking them to approve the re-domiciliation. And we thought that you should have to include details on your website prominently so people dealing with you would know that that's what you're planning to do. Again, we weren't in favour of a good faith requirement, but in this case, we did think that the National Security and Investment Act should apply and that re-domiciliation should be a triggering event, so that if you're carrying on a specified activity in a specified sector, it would be mandatory for you to notify, and you could give a voluntary notification in other cases. And again, once Companies House was satisfied that you had provided all the information you needed to, it would issue a certificate to confirm that the requirements to leave were met. Now, obviously, on an outward re-domiciliation, you're worrying about how do we protect various people who are going to be affected by this. What we suggested here was that for the shareholders, they should have to pass a special resolution to approve the proposal. We did wonder as to whether we should set out some requirements as to the sort of information you'd have to provide to your shareholders, but we concluded that we don't really do that in English law, and we have this principle that the directors have to provide sufficient information so that the shareholders are able to vote on the proposal that's being put to them. And we thought it was better to rely on that. If you've got different classes of shares, then you're going to need to get class consents from your classes of shares. And if you were going to do something that was going to increase the liability of a particular member to contribute to share capital or get them to subscribe for more shares or pay some money to the company, then you should have to get consent from every member. I think it would be relatively rarely that that would be relevant, but we did think that sort of protection was appropriate. We also thought that there should be a possibility for people who didn't vote in favour to go to court and ask for the court to make an appropriate order. We thought the unfair prejudice procedure under section 994 might be the best one for this, because the court has a very wide discretion as to what it can do, but that there should be a limited period in which you can apply to court so that the company has certainty and knows for sure whether or not someone is going to apply to court and try and stop the re-domiciliation going ahead. For creditors, again, the company would have to provide a solvency statement, which would be dated no more than 15 days before the shareholder meeting or the written resolution is circulated. And again, there'd been a requirement to update that, either if there was a change that meant that it could no longer be given, or you'd gone more than 6 months. We've tried to borrow from existing protections for creditors and say that they can go to court to object if they can show that there's a real likelihood the company won't be able to meet their debts or claims after redomiciliation, or somehow the redomiciliation is going to materially prejudice their rights. And again, there should be a limited period, and we suggested 21 days after the application form was published in the register. And the court should be able to make whatever order it thought fit to give relief where it thought that was appropriate. The way redomiciliation out of the country would work would be that the company would tell Companies House once it has been incorporated in its new jurisdiction, and then Companies House would issue a certificate confirming that they ceased to be registered in the UK, and that certificate confirming that you've met the UK requirements would only be valid for a specified period of time. Again, trying to keep the period for which you might be registered in 2 jurisdictions as short as possible. We thought there were a few additional protections that people might need. So, for example, we thought it would help if you had to have an authorised representative to accept service of proceedings for 10 years for any action that you were trying to bring out of an event that happened before redomiciliation, and that there should still be information that you could access publicly in the Companies House register about where the company has gone to, and that Companies House should keep the records relating to you for 20 years, which is what it would do if you had been wound up, for example. We thought it would help to have an index of redomiciled companies. We also thought that the company itself should have to keep its records for 10 years at a UK address, and that those should be available for inspection in the same way as they would have been if you'd stayed in the UK. And then lastly, we thought the consequences of redomiciliation out of the UK should be set out in legislation, just to make it clear that your legal personality is preserved, and make it clear that any obligations or liabilities that you have won't be affected by your move to another jurisdiction, and neither will any judgments against you or convictions or anything like that. And that it makes it clear that the choice of law that had applied before the redomiciliation took place wouldn't be affected in any way, and that it was clear that it wasn't a dissolution or a winding up. So I think the next steps are really, we want to hear from as many people as possible as to whether they think that what we've proposed is going to work in practice, and any ideas for improving it.
Perfect. Thank you, Vanessa. Such a helpful and important discussion of the report. Edmund, perhaps if I can pass over to you.
Yes. Can you see my screen okay?
Yeah.
Yeah.
Okay. Thank you very much to Anna and to Vanessa for inviting me to read this report and share my thoughts on the report with you. I should start by saying that this report was a delight to read because of how detailed the recommendations are. And this is obviously a very technical and complex subject. And it's great to read a report where it's clear that a lot of the technical difficulties that will inevitably arise have been thought through already. Now, I want to just share a few thoughts I had reading the report with you. And I want to start by just stepping back and kind of thinking about corporate mobility as a concept and why we need it, and talk a little bit about the status quo and the motivations for corporate mobility, what we should expect. Now, and then I'll talk a little bit about obstacles and challenges that might arise. So when we talk about corporate mobility, in a way, we can mean one of 3 things. first, a company may just want to move its headquarters, its business, its operations, what is often referred to as its real seat in kind of private international law, across borders. It may just want to have a different company law applied to it. So move its, sometimes it's referred to as moving its registered seat, or of course it may want to do both. Now, what's the status quo here? In the UK, moving headquarters is very easy inwards, because the UK, unlike many other jurisdictions, doesn't actually require any link between the real seat, headquarters, and the registration of the company. Moving outwards is also relatively easy from a UK perspective, even though a lot of countries on the other end of such movement do put quite a lot of obstacles in the way. And we have obviously long-standing discussions on this topic, especially within the European Union. Now, before Brexit, it was in principle possible to have a change of the applicable law by corporate mobility, by moving the registered seat across countries. However, very few companies have actually made use of that. It was very complex. There were problems with legal certainty here. And now, in a way, it's impossible directly, and that is really what the report addresses and proposes to implement. It is, however, I think, true that there are a lot of workarounds that exist, and these workarounds have, for most companies, create a situation where the economic substance of such a movement can be achieved or can be replicated quite closely. Now, what about other jurisdictions? Outside of the European Union, we have, as is detailed in the report, several jurisdictions that allow this kind of movement. My sense is that there is not a lot of activity even in those jurisdictions that allow corporate re-domiciliation. And I'll talk a little bit about why that might be. Now, there you go. Let me speculate a little bit about the motivations for making use of a future corporate re-domiciliation route. Now, my guess is, first of all, there might be some tax reasons. It might be perhaps access to double taxation agreements. It may be some sort of arbitrage between different tax systems, maybe tax reasons on the shareholder level. There will certainly also, there could be some company law reasons where a company or their shareholders believe that the current company law system is not ideal for what they want to achieve. So that could be a strong motivation. There are also non-tax regulatory reasons, for instance, access to markets, access to the single market in relation to the European Union, and so on. And that kind of raises the question for me is, how important is moving a business in the kind of non-technical sense across borders? How important is re-domiciliation for that? And I think the answer is probably not all that important, because we've seen businesses reincorporate without this procedure. And when we see them do that, very often they do that not by moving assets, moving a business across the border as such, but just changing their corporate structure and implementing a structure that is that suits their needs, rather than necessarily changing the country of incorporation of the entity holding a business or holding assets. Now, if implemented, the re-domiciliation pathway will certainly be a super important and valuable tool in complex international restructurings. And so my prediction is the vast majority of use cases for this new route would be intragroup reconstructions of groups, perhaps mainly for tax reasons. There may also be some other motivations. For instance, there might be some majority-minority conflicts between shareholders where re-domiciliation offers an easy way out. I'll talk a little bit about that later. There are also creditor distribution-related reasons. Again, I'll come back to that in a moment. And again, I think the actual kind of business transfer in the traditional sense, when you say to somebody, you know, we want to allow businesses to move across borders, I think that will be a motivation in only the minority of cases. Now, what are the obstacles? I think the obvious obstacle, and of course, Vanessa and the panel is very aware of that, the biggest obstacle is that if any jurisdiction implements a rule on re-domiciliation, it does so only for half the problem, because you can only legislate for your side of the border. And we've seen how complex that can be when looking at the history, for instance, of the cross-border merger directive. Countries tend to be very concerned about sovereignty, and without being able to legislate on both sides of the border, you inevitably run into problems such as, you know, what about shareholder protection? How final is a decision to move across borders? Now, the report recommends, as Vanessa has summarized earlier, that the applicant needs to confirm that the transaction as planned is actually compatible with the jurisdiction that you're leaving. So that is for inwards re-domiciliation, that the applicant will comply, the company will comply with the foreign applicable law and its articles, that there are no injunctions and so on. My question reading that was, isn't it likely that outside of these, you know, intra-group reconstructions, we do have relatively complex questions about the legality of that move? How firm is, you know, for instance, how meaningful is the registration of a shareholder resolution in a foreign company's register or anything like that? And so the question would be, would that imply that maybe there's a role for the court in this re-domiciliation? I understand, of course, that this is really a trade-off between you know, having those very complex questions resolved in a satisfactory manner. On the other hand, there's a major cost factor and probably also a time factor involved. Now, the proposal is perhaps inspired a little bit by the system we see in the cross-border merger directive, where the idea is, in part because of the sovereignty issues mentioned before, that certificates are issued to ensure that on each, for each jurisdiction, all the requirements are met, and those certificates are then used as a kind of conclusive proof that everything is fine on the other side of the border before going ahead. And I think that is absolutely the right strategy. However, without implementation on both sides of the border, this pure kind of confirmation and certification strategy may have its limits, because you don't have the certainty that the certificates will actually have the intended legal effect. And I think there's a more general question, kind of the political reality of these re-domiciliations. How likely is it that other countries will give access to their companies to this particular path? I think that's particularly if you look at EU countries, that is a big question mark. And my guess, my worry to a certain extent is that in relation to the UK, many European countries will revert back to the kind of old traditional approach to re-incorporations, which were either it's just not possible, or it is possible, but the requirements that you need to meet are so burdensome that in practice, it's almost always easier to do something else. Just as an example, we have been able within the European Union to reincorporate for, well, in a way, the way the European Court interprets it forever, but certainly for the past 12 or 13 years. Nevertheless, we see very, very few transactions. We have seen very few transactions, and this may change now because there's more legal certainty because it's harmonized. But before then, I think corporate lawyers have generally regarded that as a very high risk strategy where you needed extremely kind of high-powered, typically tax incentives to face those challenges. Now, there are also, I think, more general conflict of laws challenges. One has to do with the old kind of centrist type there's a certain risk that as companies leave, they will be caught up in those private international law questions about recognition of foreign companies, especially if they only move the country of registration. That could particularly be a problem, I think, when you move across, move outside of the UK. There are also a bunch of, I think, contract law challenges that we can discuss. And I think one question that has arisen within European law that could be relevant here is how do you delineate company law versus other areas of law, and in particular, how do you deal with changing company law and then deciding what part of company law actually applies to a company, as opposed to, for instance, insolvency law, as the kind of European lawyers in this webinar will know. We have had hundreds and hundreds of pages written on this and many decisions where the question simply is, company law says X, which insolvency law applies to this. Is a particular question a question of company law or a question of insolvency law for the purposes of private international law? There are a bunch of corporate law requirements where I think challenges may arise. So Vanessa detailed, for instance, for the outward re-domiciliation that we could use the unfair prejudice remedy. I think there's a certain risk that this will not always lead to the desired outcomes, because if you have a relatively short window during which you can apply for unfair prejudice relief, this kind of presupposes that minority shareholders are fully aware of the motivations, the plans behind it. And I think creative corporate lawyers, whenever you give them a new tool into their toolbox, they will find good use for it. And I think especially for minority majority conflicts, and especially for the case of leaving the UK, there are some kind of potentially risky scenarios. Think, for instance, about the ease with which minority shareholders can be squeezed out absent a public offer in most European countries, for instance, as opposed to the UK, and so on. How am I doing time-wise, Anna?
We have plenty of time left, so
yeah, okay, great. Another area where I could imagine that this is, depending on your perspective, could be very useful for corporate lawyers, for companies, is how we deal with the distribution rules. Now, the report, very understandably, I think, ends up, after a very thorough discussion, in a relatively, you could say, liberal place, where companies that re-domicile into the UK have quite a bit of flexibility in defining what sums are available for distribution ultimately. So there are some restrictions, but in effect, there will be quite a bit of flexibility. So just as an example for how detailed the report is, the report talks about how group reconstruction and merger relief would apply in case transactions took place before the re-domiciliation. But overall, I think that's will in practice be less of a concern, because companies that have limited distribution resources under foreign law will, if I read the report correctly, and of course, depending on how this will ultimately be implemented, will be relatively free in kind of restating their capital in a way that will make additional sums distributable. And given how, for instance, in private equity transaction structuring, distribution rules are really one of the driving factors. I could imagine that this is the re-domiciliation would be a tool used to manage this. Now, I mentioned that before. When we talk about trade, we use kind of the gravity model, and we say, well, the UK naturally has very strong trade ties with the European Union. Again, kind of my prediction is that if this is implemented, and really irrespective of how it is implemented, there's a good chance that most EU countries will make access to this very difficult, and perhaps access to this very difficult in both directions. So this may, to a certain extent, kind of limit the usefulness of this regime in practice. There are also a few, I think, tax law challenges, in particular, the question how to deal with exit taxation. But I understand, I mean, the panel has thought about that in quite some detail. Exit taxation obviously create a bunch of problems if upon re-domiciliation all unrealized profits need to be taxed immediately. But then if you have a solution whereby a company can stagger those payments over a certain period of time, as I understand is still the case, but certainly had to be the case before Brexit, then that creates some difficulties in relation with collaboration of tax authorities across borders, and so on. So overall, I think this is a very detailed, very thoughtful report that offers a very clear path towards regulating corporate re-domiciliation. As with all these things, in a way, the devil is in the detail. But because the report is so detailed, a lot of the questions that will arise in the later stages, consultation and implementation, are on the table already, and so it's a great basis for discussing those challenges. I have my doubts about how big this can be, simply as a consequence of political reality. Thank you very much, and congratulations on a great report, Vanessa.
Thank you very much, Edmund. All very thought-provoking comments, and I can maybe pick up a few of those now. You talked at the beginning about there being workarounds, and it is true that there are things that companies can do, but the panel was fairly convinced that there are occasions when people do want to take an existing company and bring it to the UK. And that doing a transfer of a business just won't work because of the sorts of consents that you would need to get to transfer the contracts. And so the ability to move the law you're subject to whilst keeping your legal personality, we do think would be a major step forward. And I wouldn't disagree with you. I think in lots of cases it probably would be used in intragroup situations. But that is still important nonetheless, because having your group structured in a way that's efficient and works properly and reflects the changing circumstances, it is important too. I think, there are some other pulls as well. Quite often people want to come to the UK because they think the regulation here is better than where they are. And I think also people who originally incorporated in certain jurisdictions for tax purposes, given the much greater scrutiny there now is of those tax jurisdictions, may well conclude that that's not now the right place for them to be incorporated, and so they want to go somewhere else. I accept what you say about EU member states not necessarily being keen to allow people to move out of that member state. And obviously the UK can't do anything about what other countries do, about how easy or difficult it is to move out of your jurisdiction. But it does seem to me that it's actually an important sort of sign that we want to welcome companies, at least from those countries where it is possible, to work your way through the various hoops that you have to get through. We did talk about whether the courts should be involved, because obviously we'd have a court process for cross-border mergers. And we looked, I didn't say this, but we did look at the regimes in the other countries that have re-domiciliation regimes. And most of those, as I said, use a sort of more administrative process using their registrar of companies. And as you said, we thought that the cost and time factor of having to go to court and that it might have made that question of control about exactly when does your re-domiciliation take effect a bit more difficult. And that's why we stuck with the idea of using Companies House as the body that will oversee the process. Unfair prejudice relief, yes, I think that's one of the bits where I would most welcome input from people who've got practical experience of using those sorts of that way of getting the court to deal with a concern that you have about something. One of the things that we thought was attractive about it was the very wide discretion that the court has got as to what sort of an order it can make, which can include requiring the company to buy shares or some of the other shareholders to buy shares, which might be a good way to deal with things. And we thought that the company could deal with that, because as a company, you don't want to find that as a result of re-domiciling, you've suddenly landed yourself with a large bill to buy a lot of shares. You can protect yourself against that by making your resolution to re-domicile conditional on the company not being ordered to buy back shares for more than a certain amount of money. We did think about whether we should do something more similar to the provisions in the EU directive, which have quite detailed provisions about having to pay compensation to shareholders in certain cases. But we have no tradition of that in the UK. And I suppose the only thing comparable would be the squeeze out after a takeover. But at least in a takeover, then you have a set price which the majority have accepted. So we decided not to go down that route. On distribution, yes, I accept what you say about the flexibility in setting what your share capital is going to be, and some flexibility too about how your reserves are going to be treated. I think part of what we thought about that was that it's really for the law of your existing jurisdiction to decide what are the appropriate protections. And so they, and shareholders could always vote against it, because you would expect that one of the things that the company would have to explain, both to its existing shareholders and its creditors, is what form of company it's going to be in the UK, what share capital it is going to have. And if there were significant differences between its ability to pay dividends in its existing jurisdiction and in the UK, that directors would give you some information about that too. So I hope that there are some protections there, but I accept that they're protections that rely on the law of the existing jurisdiction and its process for leaving. On the exit taxation, if you at the moment, you can be tax domiciled in the UK even though you're not a UK company, and you can also cease to be tax domiciled in the UK. And there are processes at the moment for what happens if you cease to be UK tax domiciled. And broadly speaking, the way it works is that you would have to settle your tax liabilities. There's a sort of period of time over which you would do that. So our starting point is that re-domiciling companies should be treated in a similar sort of way. So we think that there's something there. So I hope that we've come up with something practical. I know, in the time available to us, and even with the wonderful people that we had on the panel and all their experience, we still felt that there were some areas where we would really benefit from being able to expose our thinking to other people and ask them for their thoughts and input. So I very much value the comments that you've raised, and I'm hoping that there might be some more comments too. And if anyone's got any questions that they want to ask, I would be very happy to either try and answer those, or if they've got any comments or thoughts as to how it will or won't work well, I'd be interested to hear that too.
Thank you, Vanessa, and thank you, Edmund. We don't have any questions at the moment, which I think is indicative of the richness of the discussion that you've both shared with us today. Vanessa, you said the panel was open to feedback. Is there a particular way?
No, I suspect there isn't a formal way for doing
Okay.
that, but I'm very happy for people to get in touch with me and let me know any thoughts that they have. And given that I'm expecting, given that the government has said that it does plan to take this forward and that there will be a further consultation at that point, there should be an opportunity at that stage too. But early thoughts are always helpful, because then you can formulate your consultation questions in a good way so that you get the full benefit of the consultation.
Super. Thank you very much. Well, on that, we are in fact nearly at time. So I think all that remains to be said is for me to thank you both very much for your time and your expertise, and for sharing such important context and insights into what is a very important issue for the jurisdiction. So thank you very much for your time. Thank you to everyone listening, and wish you all a very good afternoon.